All right, the lawsuits against Google are starting to pile up. Viva Frei, Montreal litigator turned YouTuber, and Winnie the Westie back in the house. You will notice a sudden increase in the quality of the audio because I got my new mic. It is a Rode, one of those long mic thingies. The audio is fantastic, or at least I think it is. Let me know what you think. All right, in today's vlog, we're breaking down a class action lawsuit against Google. The facts are relatively easy to understand. It's a pretty straightforward lawsuit. It is just about time that these lawsuits start piling up against Google. Now, for those of you out there who don't actually know this, and it does blow my mind that there are still people out there who don't fully appreciate this. Google, the largest search engine on Earth, owns YouTube, the largest video hosting platform on Earth. Both companies are owned by the umbrella company Alphabet. It doesn't change anything. Google owns YouTube, and you don't have to have a very creative mind in order to know how that can possibly go wrong. But the obvious and inherent risks of the largest search engine owning the largest video hosting platform is not the subject matter of this vlog. This is a class action lawsuit against Google for deceptive business practices, as in collecting the data on children. United States District Court for the District of Massachusetts, Paula Redente, as parent and guardian of RA and RMA minors, individually and on behalf of all others similarly situated plaintiffs, versus Google LLC and YouTube LLC defendants. Jury trial demanded. Class action complaint. Plaintiffs Paula Redente, as parent and guardian of her minor children RA and RMA, the Redente children or plaintiffs, by and through undersigned counsel for their complaint against defendants Google LLC and YouTube LLC, the Google companies, allege as follows. Preliminary comment, it's the same one I do every video when we have a class action at issue. A class action is a procedural mechanism. It is not a substantive mechanism of law. So proceeding by way of class action does not change anything on the substance of the law. It is just a procedural mechanism allowing the grouping of many people when it would be impractical to proceed by individual lawsuits alone. There are certain criteria that need to be met in order to determine whether or not you can proceed by way of class action, which is all jurisdictionally dependent, and we will go over those criteria towards the end of this lawsuit, but just that preliminary word before we get into the lawsuit itself. Preliminary statement. This is a class action brought by the plaintiffs on behalf of themselves and all other children from whom the Google companies have collected personal information without express parental consent in violation of Massachusetts General Laws, Chapter 93A, Sections 2, 9, Chapter 93A. The case arises out of the Google company's unfair and unlawful collection of such information. The fact pattern in this lawsuit is not particularly complicated. We actually discussed it in the context of the Ftc complaint against YouTube a while back in the whole COPPA issue craze that went down. I think it was about a year ago now. The fact pattern is not particularly complex, so let's just take a moment right now to read the provision of law on which this lawsuit is based. Section 2A. Unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce are hereby declared unlawful. B. It is the intent of the legislature that in construing paragraph A of this section in actions brought under section 4, 9, and 11, the courts will be guided by the interpretations given by the Federal Trade Commission and the federal courts to section 5A1 of the Federal Trade Commission Act, as from time to time amended. So here you basically have the state law saying that in interpreting the state law, you're going to adopt the method through which the federal courts have interpreted the Federal Trade Commission Act, and that already led to a complaint against YouTube and a $170 million settlement by YouTube. But we will get there. Section 9 just talks about the procedural mechanisms, so let's just gloss over that real quick. Section 9(1). Any person other than a person entitled to bring action under Section 11 of this chapter who has been injured by another person's use or employment of any method, act, or practice declared to be unlawful by Section 2 or any rule or regulation issued thereunder, or any person whose rights are affected by another person violating the provisions of Clause 9 of Section 3 of Chapter 176 and what
the name am I looking at now?
May bring an action in the Superior Court or in the Housing Court as provided in Section 3 of Chapter 185C, whether by way of original complaint, counterclaim, cross-claim, or third-party action for damages and such equitable relief, including an injunction as the court deems to be necessary and proper. All right, I'm no doctor, but that seems to be a very convoluted and complicated way of saying this is how you can sue if you decide to sue. And then getting into the allegations of the class action lawsuit itself, it's not particularly complicated. They basically allege that YouTube and Google are harvesting data on children in order to market directly to those children. In September 2019, the FTC announced that Google companies would pay a $170 million fine for unfair practices in connection with the Google company's YouTube platform. Specifically, the basis for the fine was the Google company's collection of personal information from children under the age of 13 without their parents' consent in violation of the FTC Act, the Children's Online Privacy Act, and the FTC's regulations under both acts. That fine will not compensate those harmed by the Google company's unfair conduct. The United States government and the state of New York will keep the entirety of that fine. So the argument here is that that's a nice hefty $170 million fine that the Google companies agreed to pay to the government. It's a drop in the bucket as far as their profits go, and they will not even feel it as much as a pinprick, but it's a nice fine to pay, except it doesn't compensate the actual victims of their egregious over-the-line conduct. The Google companies have engaged in unfair acts in violation of Chapter 93A by collecting personal information such as persistent identifiers from viewers it knew were children under the age of 13 without providing notice to or obtaining verifiable consent from the children's parents. The Redenti children, for example, have consistently over the last 4 years viewed channels on YouTube directed to children. The Google companies have collected personal information concerning the Redenti children through their use of those channels. At no point have the Google companies obtained consent from children's parents, including Paula Redenti. It is no secret that many, if not most, children in Massachusetts under the age of 13 have likewise regularly viewed YouTube, and the Google company's unfair acts and practices have been the same as to all such children. They have collected and used personal information of such children in violation of COPPA, the FTC Act, and Chapter 93A. And it's not just that Google did it, they made tons and tons and tons of money by doing it. The Google companies have derived substantial profits from their unlawful collection of personal information through YouTube from Massachusetts children in the form of advertising revenue generated as a result of its targeted advertising, which in turn depends on its collection of personal information. The profits the Google companies obtained from their unfair acts and practices reflects the damages the class has suffered from the conduct, i.e. the value of the personal information that Google companies unfairly collected and used. The Google companies are liable to plaintiffs and class members for all damages resulting from Google's company's unfair acts and practices described in this complaint. We can skip over a lot of this lawsuit, the parties, the jurisdiction, a lot of the facts, because we already basically know them. The most important thing to understand in the context of this lawsuit is the difference between standard general advertising and advertising that is based on behavioral conduct. Advertising that is based on behavioral conduct is not general advertising to a group at large. It is basically tailor-made to target specific individuals based on their behavior, and it is called behavioral advertising. It sells for a lot more than general advertising. Unlike television advertisements, in which the same advertisements are shown to all viewers on a particular channel at a particular time, or at least all viewers watching a particular channel within a certain geographical area, advertisements on YouTube can be customized to the particular viewer. YouTube has pioneered what is known as, quote, behavioral advertising, end quote, which serves advertising to particular viewers based on information the platform has concerning that viewer. Such information may include YouTube viewing history and other information the Google companies have collected through a particular user's usage of other services, including Google services. Such, quote, behavioral advertising, end quote, is activated by default on monetized channels. To maximize the customization of advertisements through behavioral advertising, YouTube keeps track of all videos viewed by a particular viewer. This tracking can occur through a viewer being logged into their Google account, in which case YouTube can track the history of videos viewed by that account. Alright, so I hear a lot of you out there already saying, well, that's all fine and well if you're logged into your account. If you don't want Google and YouTube tracking your data, just don't log into your account. The problem here, they gather that information even when you're not logged into your account. Or at least that is the allegation of the lawsuit. Even if a viewer is not logged on, however, YouTube can track the videos a particular viewer views by using, quote, cookies, end quote, in a web browser and, quote, mobile advertising identifiers, end quote, on mobile devices. Cookies and mobile advertising identifiers are pieces of code stored on a user's device that a website or application can use to identify that individual, even if the individual is not logged into an account on the website or application. The Google companies use these technologies to track the viewing habits of users of YouTube even when they are not logged in, which then enables the Google companies to serve behavioral advertising, that is, advertisements targeted towards particular individuals based on their viewing habits. The lawsuit then goes on to explain how Google collected the data on children so that they could actually use this marketing specifically to target those children and basically charge a premium for that kind of advertising. The lawsuit explains how there were specific channels that were basically targeting children in particular, but then it goes on to say something which I find particularly interesting about blurring the lines between content and advertising. Toy makers have gone even further than advertising on child-oriented YouTube channels. Many have created their own channels on the platform, blurring the lines between entertainment and advertising. There are YouTube channels for Barbie, Monster High, Hot Wheels, Thomas & Friends, and numerous others. One of the most popular YouTube channels among kids, Ryan's World, is essentially a running advertisement for the newest toys as, quote, Ryan, end quote, opens and tests a seemingly endless stream of toys sent to his home by toy makers. Despite the fact that the Google companies themselves classify videos as being designed for young children, the Google companies did not treat channels or videos directed to young children any differently for the purposes of data collection collection from other content on YouTube. That is, the Google companies continue to allow the channel owner to monetize, quote, Y, end quote, rated content and earn revenue from behavioral advertising. That is, customized advertising based on the collection of viewing history and other personal information about the child. YouTube hosts thousands of channels that are directed to children as reflected in the subject matter, visual content, language, and use of animated characters or child-oriented activities. Many YouTube channels pitch themselves as being for children. The FTC's complaint against the Google companies cataloged many such examples of channels specifically directed to children. A peculiarity to this lawsuit, which I think is really going to hurt Google and really bolster the complaint from the plaintiff, is the fact that there was an FTC complaint against Google specifically on this subject, and Google basically didn't plead guilty, but agreed to settle that complaint for a $170 million fine. Whether or not that constitutes an admission of guilt, you know the plaintiff is going to rely on that in this complaint, and they do so in the paragraph I'm about to read to you now. As reflected in the FTC's complaint against the Google companies openly flouted the FTC rule and therefore engaged in unfair practices under the FTC Act. Specifically, A, the Google companies operated an online service directed to children, specifically YouTube, and the Google companies had actual knowledge that they were collecting personal information concerning children. The Google companies routinely collected personal information from children, including most significantly through the use of personal identifiers that tracked children's YouTube viewing for the purposes of serving behavioral advertising. C, the Google companies failed to obtain verifiable parental consent prior to collecting, using, and disclosing children's personal information. The lawsuit then goes on to repeat what we had already seen in the beginning, that in interpreting the state law, one has to give it the interpretation of the federal act, which was good enough for the complaint and good enough for the $170 million settlement, and should be good enough for this particular complaint. Plaintiffs bring this action pursuant to Rule 23 of the Federal Rules of Civil Procedure on behalf of themselves and a nationwide class consisting of, quote, all children residing in Massachusetts who, at a time when the children were under the age of 13, viewed videos on YouTube and from whom the Google companies collected, used, or disclosed personal information without first obtaining verified parental consent, end quote. The lawsuit then goes on to explain why the class is properly defined. Yes, what's going on?
I almost forgot Gertrude's name.
Okay, we have saved and are going to try to raise some tadpoles, and they've already given them names.
No, we gave him two names, but those were the first ones we got. Gertrude and Timothy.
Okay, can I finish my video?
Yes.
Okay, thank you. Close the door to my office, please. The lawsuit then goes on to allege why the group is properly defined, why the questions of law are going to be common for every member of the group, the damages sustained going to be similar for all members of the group. I'm going to flash that right now if you want to freeze frame it and read it for yourself. And then the lawsuit finishes by referencing the count on which the lawsuit is based. We already read it, but let's just see it again. Count 1, Massachusetts General Laws, Chapter 93A, Sections 2, 9. On behalf of all plaintiffs and the class. Plaintiffs incorporate the foregoing paragraphs as if fully set forth herein. The count is pled on behalf of plaintiffs and the class. At all relevant times, the Google companies were engaged in trade or commerce within the Commonwealth of Massachusetts, including the trade or commerce of providing the YouTube service within the Commonwealth of Massachusetts. By conducting the acts and practices described above, the Google companies have engaged in unfair acts or practices in the conduct of trade or commerce in violation of Chapter 93A, Sections 2 and 9. Okay, so that is the lawsuit. It seems relatively like a no-brainer to me. The $170 million fine that YouTube and Google agreed to pay in the FTC complaint, I think that is going to be used against them in the context of this lawsuit. But the bottom line, I don't think there's going to be any denying that Google did that which they are accused of having done in this lawsuit. The only question is going to be the quantum of any damages they are ordered to pay or they agree to pay. And then it's just going to be a question of whether or not any penalty or fine they are ordered to pay or any settlement is just going to be a cost of doing business. Break the law for as much as you want, for as often as you can, until you get caught. And when you get caught, the penalty will not be as much as the profits you made while breaking the law. All right, I think this video is over. Give me the dotted line. All right, with that said, if you like my videos, you like my content, please be sure to like, share, subscribe. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, merch, anti-media, Robert Barnes, live streams. More important than that, take care of yourselves. Get up. Check in on friends and family. Make sure everyone around you is doing fine. And now you know you've vlogged. Peace out.